Why?
Why?
Why did I get a ticket?
It's not a ticket. It's a misdemeanor.
You don't know which one.
Oh no, the pink one.
Oh, you ready? I got the pink one.
Let me just confirm real quick.
I don't have any.
One of the pink is
I
on,
lost
correct?
all my friends. Air. Why? I do.
Where's your car, Emma? Over there? Alright. Right here?
I don't think we're
Let me double watch the screen right here.
Put them cuffs on that ass. Give me a paper spectrum.
in your stance. There you go. Before I start to use their next, I need a coping strictly and
Is this the same printer that you had before?
No, I don't have a printer.
You gonna get your car?
Huh?
You doing a 1035?
Yeah.
Oh, you're in a Sploner. Okay, that's what it is.
Just get turned off.
Would you just put the 1015 on the one last one I had?
Alright, well, just so you know, we're taking care of it. Alright, no, line your face, folks. Sorry. There you go. Sorry.
Is your bank card?
No. No, he used it.
I was making sure it was one of you guys' cards, so they won't.
Oh, they're my cups.
That's my card, yeah.
They're my cups. Hey, Cavender. Cavender, did you already send it for approval?
No, I went through the sign.
Oh. But
I don't think it has to be approved to get signed off on.
Hold up. I have one in my...
It ain't
did you
there?
already see the
On
real
me,
ID?
no. But I do have the fingerprint card.
Who's that? That was found on her? Her
Yeah, it
person.
was in her back pocket.
Are we doing APAC?
Y'all kill me.
Hey, don't look at me.
On April 24th, 2025, law enforcement officers conducted a misdemeanor arrest of a college student following a failure to verify her identity. The footage raises three distinct legal questions: the lawfulness of the custodial arrest, the constitutional sequence of the identity search, and the discretionary use of arrest over citation. On the question of custodial arrest for a misdemeanor, the Supreme Court addressed this directly in Atwater versus City of Lago Vista in 2001. The court held that the Fourth Amendment does not prohibit a full custodial arrest for a minor criminal offense, even one punishable only by a fine. This means the arrest itself was constitutionally permissible, regardless of the severity of the underlying offense, provided probable cause existed. However, Atwater does not compel custody. It merely permits it. Many states authorize cite-and-release procedures for nonviolent misdemeanors. A citation, also called a notice to appear, achieves the same legal objective as a custodial arrest, while imposing a significantly lower burden on the subject and on department resources. Whether that option was available to the officers here depends on the jurisdiction's statute, which this footage does not confirm. That ambiguity is legally significant. The second legal issue concerns the discovery of the subject's identification card in her back pocket and the constitutional sequence surrounding that discovery. Under Chimel v. California, decided by the Supreme Court in 1969, officers may lawfully search the person of an arrested individual and the area within their immediate control. This exception, known as a search incident to arrest, serves two purposes: officer safety and prevention of evidence destruction. The critical constraint is sequencing. The arrest must precede the search. If the pocket was searched before probable cause was formally established, the discovery is constitutionally compromised. The footage does not clearly establish the moment of formal arrest relative to the moment the ID was found. This gap in documentation represents a procedural vulnerability that defense counsel would exploit. The exclusionary rule, established in Mapp v. Ohio in 1961, bars the use of evidence obtained through an unconstitutional search. If the ID was obtained unlawfully, it cannot be used against the subject. The third issue is identity verification itself. Officers stated they could not verify who the subject was and cited this as a factor in the arrest decision. Stop and identify statutes in many U.S. states require individuals to identify themselves to officers during a lawful investigatory stop. Failure to do so may independently constitute a misdemeanor offense. The Supreme Court upheld stop and identify statutes in Heibel v. 6th Judicial District of Nevada in 2004, finding they do not violate the Fourth or Fifth Amendments when the underlying stop is lawful. However, the subject's inability to produce identification was not deliberate concealment. She stated she was unaware the ID was in her own pocket. Willfulness is a relevant factor in assessing culpability. On the question of equal protection, the subject asked why she was singled out. The officer's response confirmed this was part of a broader enforcement operation targeting multiple individuals. The 14th Amendment requires that enforcement be applied without unlawful discrimination based on protected characteristics. No evidence of discriminatory targeting is apparent from the footage. The subject was not entitled to a Miranda advisement at this stage. Miranda applies to custodial interrogation, the asking of questions designed to elicit incriminating responses. The dialogue here was informational, not interrogative. The officer's pre-booking advisement instructing the subject to comply with facility staff reflects professional standard practice and is consistent with department duty of care obligations.
Yeah, it was in her back pocket. She went, oh yeah, that's just old. Stop, really?
Oh, that's in her back pocket.
Is that the only thing you needed?
Yeah, we couldn't verify who she was.
Not to be a good this.
I was gonna say she found it.
Yeah. No. I meant
Are we
the
changing it
girl
up?
who
Yeah.
we're telling
Okay.
her you're
She's
going to go to
going
jail without your ID. Do you think she would know?
Okay.
Now she's.
It happened.
Well, Blade should be happy.
No, that's my car.
Oh.
Yeah. I don't give it away. I just can't turn the car on. Question for you. Did you know your ID was in your back pocket the whole time?
No.
You didn't know?
I had no idea.
Okay. You understand that that's all we needed, right? For you not to go to jail?
My ID?
If you want to bust out the other one, well, I'll do it real quick, actually.
No, I
if you
can
would,
just
not
copy and
bust out.
paste it.
Huh?
I can just copy and paste it, right?
Pretty much, yes.
Yeah. I just need the fake one.
My
or whatever.
ID is in my friend's.
Hold that.
Just a question.
Yes, Miss Molly.
Why am I handcuffed?
Again, because you're under arrest.
No. Like, why?
Why?
Why did I get a ticket?
It's not a ticket. It's a misdemeanor.
No, but like, why couldn't you just give me a ticket?
Because it's not a ticket.
Like, why?
Because that's what the law states. It's a misdemeanor.
Why can't I just go home?
Well, there's still a chance.
I hope. Why did I get picked out of everybody?
You weren't the only one. There's lots of people.
No, but like, why? Like, I just want to go home. Like, when you start your shift today, did you think you'd be arresting, like, me?
Well, I knew we'd be arresting college kids. Absolutely. Absolutely. Because unfortunately, this is a problem, right?
A big problem.
A big problem. A ton of people are doing this, and it's not okay.
Do you feel sorrow?
Sorrow? Well, I'm empathetic. Absolutely.
Listen, you were in college once.
I was. I would hope I'd be in college. I think I need that for this job.
Arresting officer grade B-. The officer maintained composure, demonstrated empathy, and provided appropriate pre-booking guidance. The arrest was constitutionally authorized under Atwater. The grade reflects two concerns. First, the failure to clearly document the sequence between probable cause, the search, and the formal arrest, creating a Chimel vulnerability. Second, the absence of any visible consideration of cite-and-release alternatives. Subject, grade B. The subject did not physically resist, complied with custodial directives, and expressed her objections through speech which is constitutionally protected under the First Amendment. The grade reflects one avoidable error: the failure to know the contents of her own pockets. Under Stop and Identify doctrine, the ability to produce identification on demand is a practical legal protection, not merely a courtesy. Lessons from this encounter. For law enforcement, document the precise moment probable cause is established before initiating any search of the subject's person. The Chimel exception requires the arrest to precede the search, not follow it. When a cite-and-release option exists under state law, weigh it deliberately. Custodial arrest for a non-violent misdemeanor, where a citation would suffice, increases civil liability exposure without a corresponding public safety benefit. For citizens, carry identification and know where it is. Identify yourself clearly when lawfully detained. Exercise rights through speech and through the courts, not through physical resistance, which escalates risk without legal benefit. If you believe an arrest is unlawful, the correct remedy is a motion to suppress, a Section 1983 civil rights claim, or an appeal, not refusal to comply at the scene. Let us know if there is an interaction or legal topic that you would like us to discuss in the comments below. Thank you for watching, and don't forget to subscribe to the channel for even more police interaction and courtroom content.
All right, Miss Lily. We're gonna go this way. We're gonna walk towards the building. You're an adult. I'm not gonna.
Sorry.
You're good.
Can you let him out the pee, please?
Yep.
So bad.
Let me tell you one thing. Once you're in here,
Uh-huh.
listen to everything they tell you to do.
Uh-huh.
All right. You back talk them. You don't listen. You talk
be
over
mute.
them. Again, don't be mute. But again, talk with them. Don't hit the tree. Again.
I just want to go home.
I understand.
Do you understand? I just want to go
Judging
home.
Bodycam. At Oriental Road Jail.